Hi, I'm Jessica DeMichiel, and I'm a healthcare attorney with the Coppola Firm. And I'm here to talk to you today about things you need to think about if you're about to leave the employment of a practice. Now, the first thing you're going to want to do if you decide you're going to leave a practice is review your employment agreement for non-competes and non-solicitation clauses. So what is a non-compete? A non-compete prohibits a provider from practicing within a certain radius of a former employer for a set period of time. So it could be a 5-mile radius of your actual practice location or any practice of your prior employer. And it can be for a period of, let's say, a year, 2 years, even 5 years. And then you may have a non-solicitation clause. And a non-solicitation clause is a clause that's going to prevent you from actively seeking the transfer of your patient base to your new employer or seeking the transfer of employment of other staff at your prior employer to come work for you at your new practice or new employer. Now, non-solicitation clauses, those are typically going to be enforceable. However, non-competes can be challenged. They can be challenged with respect to how broad they are. So, is the radius too broad? The number of years too broad? Is the locations by which you can't practice from too broad or too many? And they may not serve a legitimate business purpose of your former employer. So there can be grounds to challenge a non-compete. And if you have questions about that, we'll be happy to look at them and give you our advice on your particular non-compete. The next thing you're going to have to think about when you're leaving a practice is whether or not your current patient base are going to be notified that you are in fact leaving your former employer. Now, this really depends on, first of all, what are your former employers' practices? What have they generally done with other providers in the past? Then you're going to look to your contract. Does your contract have any sort of language in it where it requires your former employer to give some type of notice to your patients? And the fact about whether or not there are other providers at the practice who can continue providing the same care, treatment, or services that you've provided in the past. If you're leaving an employer and there's nobody there who's going to be able to render the same care, treatment, or services as you, then it doesn't matter what the employer's past practices are or what your employment agreement says. Those patients are required to get notification under the law. Now, it's important to know that patients do have the right to choose their own providers. So if you decide to leave a practice, and even if you have a non-solicitation clause in place, as long as you're not actively soliciting those patients, if they find you, they can choose to come to where you practice at your new employer. So that's important to know that patients should be given the choice of their providers. Typically, they'll call your former employer. They can be given an alternate provider there at your former employer's practice. But if they ask where you're at, or they want their records transferred to you, as long as you don't actively solicit them, then they're going to have the right to choose to come to where you are. The next thing you're going to want to do when you decide you're going to leave a practice is to review your contract to determine what is the proper method by which you're going to give notice that you're terminating your employment. And you want to make sure that you give notice of termination in a way that makes sure you're still going to be entitled to any type of severance pay or post-termination compensation. And a lot of the times your employment contracts are going to require that notice to be given in a very specific manner. So sometimes it's in person. Sometimes it can be via a hand delivery service. Sometimes it can be via mail, but it has to be registered or certified. And usually there's a set time period such as 30, 60, or 90 days by which you're going to have to give that notice. And really that's also going to be dependent on whether it's a for-cause notice or not for-cause notice, where there's really not an actual material reason or material breach of your contract or what you are entitled to it that's making you leave at the end of the day. The last thing you're going to want to look at is, are you entitled to post-termination compensation under the contract? And to ensure that if you are entitled to it, that that's paid out accordingly. The very last thing you're going to want to look at is, does your contract have any type of confidentiality or non-derogation clauses in it? This means that you can be significantly impacted by what you or even your former employer is able to say about you to potential future employers, patients, members of the public. So you may be prohibited from sharing confidential information as you move on, or from making negative or harmful statements about your former employer and vice versa. And you have to be cognizant that there is a potential for legal action to be taken against you if you engage in that conduct, or if your employer engages in that conduct against you, and that there can be methods by which either you or your former employer can be compensated if that type of conduct occurs. If you have any other questions on this topic, feel free to reach out to us at the Coppola Firm, and we'll be happy to answer any of your questions. Thank you.